Request a free legal consultation with an independent immigration attorney at permanentresident.us. You may be matched with a different attorney.
The question is, what is the EB1, specifically the EB1A green card, and what is the EB2 NIW green card? What are they? What are the definitions of them, and what are the differences between them? The EB1A green card pathway is for persons who are considered of extraordinary ability. That means that they are at the very top of their field of endeavor, that they show they have sustained recognition, usually at least nationally or globally, for the field and what they do. That's compared to the EB2 NIW. NIW stands for National Interest Waiver. And to show that you qualify under that category, you specifically need to show that your work and your field are in the interest of the United States as a nation. The question is, what is the benefit of, or what are the benefits of the EB1A or the EB2 NIW National Interest Waiver categories compared to other employment-based green card pathways like EB2, the regular EB2, or EB3? The answer is there's multiple reasons. The first one is definitely that it is a faster process to go through EB1 and usually through EB2 NIW. It's faster because you are not required under those categories to go through the labor market test. You may have heard of something called PERM. It's also known as labor certification. That requires a U.S. employer to test the job market to show the U.S. government that they've tried to hire persons who are already in the U.S. as U.S. citizens or green card holders already themselves. And after going through that hiring process, if they can show that they were not able to hire anybody locally, then that's the reason they should be allowed to sponsor a particular person, a foreign national coming into the U.S. for a green card. That process by itself takes a very long time, around 8 months to a year or more, and that's adding on to the overall green card processing time. So the benefit of the EB1 and the EB2 NIW is that you don't need to go through that market test step. The EB1 is for persons of extraordinary ability, and the EB2 NIW is for persons who are going to be in the national interest of the United States. And the U.S. government, U.S. Congress, they determined that it's worth it to sidestep the labor market test because these persons are either going to be bringing their extraordinary ability to the U.S. or they're going to be serving the U.S. national interest in some important way. And that is a huge time savings to those persons in terms of how long it takes to get their green card. The second reason is that immigrant visa number availability has been traditionally much better for persons, at least for the EB1A category. EB2, you're unfortunately still limited to the overall EB2 criteria, but for EB1 folks, especially those coming from China, India, Mexico, and the Philippines, EB1 availability has been traditionally much, much better, and the wait time just to eventually get your green card is much shorter. So those are the two primary benefits. The last one is just a feature of both the EB1A and the EB2 NIW is that you can self-petition under those categories. So you don't necessarily need a U.S. Employer petitioning for you. You don't necessarily need a U.S. job offer, as long as you can show that you're going to be doing some kind of work activity in your extraordinary ability field, or something that, again, that's going to be in the United States national interest. The question is, how long does it take to get a green card, to get U.S. permanent residence under the EB1A category? At present, it takes approximately 1 to 2 years, depending on certain factors, and also there's some variability in processing times with U.S. immigration. So the question is, if you are a person of Chinese or Indian nationality, will it take longer to get a green card under the EB1A category? And the answer is, at present, it should not. The visa availability for EB1A is still available across the board for persons from all countries. The question is, how long does it take to get a green card, get U.S. permanent residence under the EB2 NIW category? And the answer is, it depends in part on which country you were born in. Because the NIW is under the EB2 category, it's subject to certain visa number limitations under EB2, and certain countries, including persons who are coming from China, India, Mexico, and the Philippines, may have visa number limitations that they'll have to consider. If you are not from one of those countries, overall, the process takes approximately 1 to 2 years. But you should check, if you are from one of the countries that I just mentioned, you should check the visa availability, as those may cause additional delays. For which persons might benefit more from applying under the EB1A category versus the EB2 National Interest Waiver category. There's two categories really, or there's two types of persons. First, if you come from one of the countries that are considered quote-unquote oversubscribed, so that's going to be China, India, Mexico, or the Philippines, visa availability under the EB2 NIW is still fairly backlogged. So just in terms of wait times, if you can qualify under EB1, that would most likely benefit you instead, as the availability under EB1 is much better for persons from those countries. The other factor to consider is the eligibility requirements for the EB1 versus the EB2 NIW. NIW is, again, it's the National Interest Waiver, and you have to show that your work is going to be in the interest of the United States. If you're not able to show that, you may be better off trying to go for the EB1, showing that you have general extraordinary ability in your field. Of course, the same in reverse holds true. If your work is definitely something that's going to benefit the United States as a whole, and you can clearly show that, you might want to try to go for the NIW. The question is, does obtaining an O1 visa help anybody or help an applicant get an EB1A green card? And the answer is not necessarily. The O1 is the non-immigrant version of the extraordinary ability visa. It's meant for persons to come to the United States on a non-immigrant basis, in other words, a temporary basis, to work for a temporary amount of time in the U.S. A lot of the criteria for the O1 and the EB1 do overlap, but just because U.S. immigration approves an O1 does not necessarily mean that means that they're going to automatically approve an EB1 as well. That being said, working on an O1 does help quite a bit because, again, as I mentioned, there is a lot of overlap in terms of evidence. Working on an O1 can help you gather a lot of the required things you'll need to show for the EB1. But, again, I always tell persons that just to be careful that they cannot assume that an O1 approval is going to also equal an EB1 approval. The question is, what can an applicant provide as evidence to show that they qualify for the EB1 criteria, for the EB1 category? And I normally advise folks that U.S. immigration is looking for objective evidence. So that means that they are looking for things beyond just letters of support coming from your former colleagues or persons who know you. They are looking more for things that can be independently verifiable. And if you'd like to see examples of that, please click on the link that we'll provide. That'll give you more concrete examples of such types of evidence. The question is, what kind of awards count towards the eligibility requirements for the EB1 category? And the overall guideline that you want to follow is that awards that can be generally available to a wide population, those are the ones that U.S. immigration is looking for. So as an example, an award that is given as a scholarship only to students of a particular university or college U.S. Immigration is going to say that the population who could potentially win that award is fairly narrow. And it's hard for them to conclude that someone has reached the top of their field based only on that award, since the population that award actually proves that you're the top of. Again, it's a very narrow population, only a student body at a specific school. But if you get a wider award, an industry award, for example, let's say it's an award given out to computer scientists or computer engineers, you can show that award reaches and it is eligible for a much wider audience, and that means that you've reached the top of the field of that wider audience of that field of endeavor, and is much more impressive to U.S. immigration. So the question is, one of the criteria for the EB1 is being a member of an organization that requires high achievement, of extraordinary achievements of its membership. So what counts as such a membership? Does that include professional organizations? And the answer is, it depends on the organization and what they actually require. A good example I use is the IEEE, the Institute for Electronics Engineers. And the IEEE has several levels of different types of memberships. There is a general engineering membership where I believe if you just pay certain dues to the organization and show that you're an engineer, they'll give you that membership. But that doesn't necessarily require you to show high achievement. But there are higher tiers of membership in the IEEE where the organization asks you to judge other engineers, to opine or review other person's work, and that does require, the IEEE does require the person to show that they've reached a high level of achievement in their own right. So you really need to look at what the organization requires of you to determine whether or not that membership is going to count or not. One of the requirements that you can show for the EB1A rather is that you have published scholarly articles, you've published articles about your work in your field. And there are certain articles that U.S. Immigration does look for there. The general rule of thumb is that if your work reaches a wider audience, that it reaches your field or your industry as a whole, that's more likely to be considered the kind of publication that U.S. Immigration is looking for, versus, let's say, just like a small-scale blog or post on your own personal website, where you're not really showing or you're not able to show many people have viewed the article. Those things are most likely not going to be considered the kind of publication that U.S. Immigration is looking for. So the question is, do online blog posts or online journals or similar count towards publications that might qualify you for one of the EB1A category criteria? And the answer is it may, depending on how much of a reach your blog posts have. You'll need some way to show that your posts, your publications in that format and that media have reached a lot of viewers. A typical way of showing that is web impressions. There is a website that I sometimes use called SimilarWeb, which can show specific websites, specific platforms, how many hits that they get. And if you can show that the platform where you've posted your blog post, for example, has millions of page views, that means that you're reaching a wide audience, and that would be something that would move the needle for U.S. immigration. One of the criteria for the EB1 is if you can show that you have judged the work of others. And the idea is that you're showing that your field, your industry considers you as an expert such that they look to you to judge others in that work. So the question here is, does judging for judging for university competitions or judging for a thesis panel, does that count? And the answer is it depends. one of the things that U.S. immigration is going to be looking for is whether your judging is on a large scale. Some university competitions do have a fairly wide audience. Sometimes the scope of those competitions are actually industry wide or field wide, such that they invite other persons from other universities or other research institutions to take part in a specific contest. If you can show that it has wide impact, that is something that could be potentially impressive to U.S. immigration, and you'll certainly need to provide objective evidence to show that. The question is, for the EB1 classification, one of the criteria is showing that your work is your work is of a nature of making original contributions that are majorly significant to your field. And one way that a lot of applicants for the EB1 try to show that is showing that they have patents. That they've submitted patent applications or that they've been approved for certain kinds of patents. And the underlying question there is, what kind of patents and how many patents do you really need to show? And does commercializing or showing commercial results from a patent, is that absolutely required? And so the answer to all of that is, again, U.S. immigration is going to be looking for the impact, the significance of your work. Just having a patent by itself, that shows maybe you have an original invention, but the patent by itself isn't going to show necessarily that your work is original. The other part of that U.S. immigration is going to be looking for is that it is of major significance. It doesn't necessarily mean you have had to commercialize that patent. You can show that your patent has had reach in other ways. There are researchers can cite to patents. And I have worked with persons who have shown that their specific patents have had high citation counts instead. It's an alternative way of showing that the patent has had huge reach among their field, among their academic peers or researchers. The other question there being that having a high number of patents isn't necessarily indicative either of originality. The U.S. immigration isn't going to just say this person has hundreds of patents, that must mean that they are of extraordinary ability. That's not necessarily the case. Again, what they're going to be looking for is also the impact of those patents. So you'll want to provide some sort of objective evidence in addition to your patents to show that you've had significant reach in your industry or your field. So the question is, one of the criteria for the EB1A, one of the potential criteria you can show is that you've served in a critical role for an organization with a distinguished reputation. Persons ask, persons who want to apply ask, does it matter what your job title is to show that you've had a critical role? And the answer is not necessarily. U.S. immigration isn't just going to look at the job title alone. They are going to look at the underlying duties that you had, and they are also going to want to know, whether your role actually was critical or not. The question I always ask persons looking at this criteria is, without you, would that organization, that company or employer, would they have been able to achieve the level of success that they did, had you not been there? That's the question I usually pose. That being said, the job title should match with what you were doing. The typical example I talk about is if you are in a CTO, a Chief Technology Officer type role with a company and you led the development of a highly valuable software product that made millions of dollars in revenue for a company you worked for, it's not going to make too much sense if your job title there was just software engineer. You want to have your job title be CTO or something similar. So there's some context there, but the job title on its own isn't going to make or break your case. So the question is, one of the criteria for the EB1A, one of the potential criteria you can show is that you've served in a critical role for an organization with a distinguished reputation. persons who want to apply ask, does it matter what your job title is to show that you've had a critical role? And the answer is not necessarily. U.S. immigration isn't just going to look at the job title alone. They are going to look at the underlying duties that you had, and they are also going to want to know, whether your role actually was critical or not. The question I always ask persons looking at this criteria is, without you, would that organization, that company or employer, would they have been able to achieve the level of success that they did, had you not been there? That's the question I usually pose. That being said, the job title should match with what you were doing. The typical example I talk about is if you are in a CTO, a Chief Technology Officer type role with a company, and you led the development of a highly valuable software product that made millions of dollars in revenue for a company you worked for. It's not going to make too much sense if your job title there was just software engineer. You want to have your job title be CTO or something similar. So there's some context there, but the job title on its own isn't going to make or break your case. I think the question is for persons thinking about applying for the EB1, how can they leverage their academic or their scientific research work to support their application? And I think this goes to one of the things that U.S. immigration is going to be looking for, in that your academic, your research work has had significant impact on your field, on your industry, and perhaps on a wider audience as well. You'll want to show that you have some sort of objective evidence showing that your work has reached broader audiences and has moved the needle for them. So that can happen in a number of ways. The traditional way that the U.S. immigration often looks for is citation counts. If your research work has been cited quite a bit, that is of course showing impact on your field, that a lot of others in your field are using your work. Other ways that are traditional are showing that your work has been commercialized and that you've achieved commercial success. So you'd want to show things like contracts, sales contracts, licensing agreements, revenue figures, specific revenue figures directly resulting from your research work, and that can show an objective level of achievement. And you can also want to point out any kind of press mentions, any major media discussing your work and the impact your work has had. Ideally, the media would be mentioning you specifically by name and discussing what it is that your work has done. Really, U.S. immigration is looking for these objective points, these objective types of evidence to show that your research work has had that sort of impact. So you'll want to try to position yourself as much as possible and gather that sort of evidence as much as possible to leverage your research work to help you try to qualify. The question is, for the EB1A category, do you need an employer sponsor or a job offer? And the answer is not necessarily. The EB1A does allow applicants to self-petition. You can file a petition for yourself as long as you can otherwise show that you do meet the extraordinary ability category and the criteria. You will additionally, though, need to show that, again, you don't necessarily need a job offer exactly or even an employer sponsor, but you'll need to show U.S. immigration that you have a credible plan in which you'll be working in your field of extraordinary ability, or you'll be doing some sort of professional activity in your field of extraordinary ability. But you don't necessarily need an employer sponsor for that or an actual job offer.
Okay. Is the EB1A green card open to any field? Repeat or rephrase.
Sure. The question is the EB1A, can you qualify for the EB1A through any kind of field? And the answer is it's fields, the law says fields of human endeavor. So that doesn't, the traditional thing that I think a lot of people they assume is that people are going through the EB1A are in a STEM field, a science, technology, engineering, or math field. And that's not necessarily the case. There are persons who can qualify through arts. There are persons who can qualify through business achievements. As long as you are able to show that you've reached the very top of your particular field, that you have extraordinary ability and that you are the tops among your peers, that can qualify, and it doesn't necessarily need to be a STEM field at all. The question is, does an applicant need to have a PhD degree to qualify for the EB1A permanent residence category? The answer is not necessarily. You can show that you have extraordinary ability in other ways aside from having a doctorate or a PhD degree, with the caveat that for some kinds of fields, especially fields in science, technology, engineering, or math, it will make more sense to U.S. immigration that you have a PhD in that field. There's some context there, but it's not an absolute requirement that you have to have a PhD to qualify. The question is, for the EB1A category, do you need an employer sponsor or a job offer? And the answer is not necessarily. The EB1A does allow applicants to self-petition. You can file a petition for yourself as long as you can otherwise show that you do meet the extraordinary ability category and the criteria. You will additionally, though, need to show that, again, you don't necessarily need a job offer exactly or even an employer sponsor, but you'll need to show U.S. immigration that you have a credible plan in which you'll be working in your field of extraordinary ability, or you'll be doing some sort of professional activity in your field of extraordinary ability. But you don't necessarily need an employer sponsor for that or an actual job offer.
Okay. Is the EB1A green card open to any field? Repeat or rephrase.
Sure. The question is the EB1A, can you qualify for the EB1A through any kind of field? And the answer is it's fields, the law says fields of human endeavor. So that doesn't, the traditional thing that I think a lot of people they assume is that people are going through the EB1A are in a STEM field, a science, technology, engineering, or math field. And that's not necessarily the case. There are persons who can qualify through arts. There are persons who can qualify through business achievements. As long as you are able to show that you've reached the very top of your particular field, that you have extraordinary ability and that you are the tops among your peers, that can qualify, and it doesn't necessarily need to be a STEM field at all. The question is, does an applicant need to have a PhD degree to qualify for the EB1A permanent residence category? The answer is not necessarily. You can show that you have extraordinary ability in other ways aside from having a doctorate or a PhD degree, with the caveat that for some kinds of fields, especially fields in science, technology, engineering, or math, it will make more sense to U.S. immigration that you have a PhD in that field. There's some context there, but it's not an absolute requirement that you have to have a PhD to qualify. The question is, does an applicant need a PhD degree to qualify for the EB2 national interest waiver category? And the answer is not necessarily. The national interest waiver, the primary test there that you're trying to show is that your work is going to be in the interest of the United States as a nation as a whole, and you don't necessarily need to have a PhD to qualify there for that. The question is, if an applicant is able to get or apply for a green card through the EB1A, can their family members also get green cards and U.S. permanent residence as well? And the law provides for dependent green cards for specific persons, for spouses who you were lawfully married to, and for children who are under the age of 21. So the lawfully married one catches a lot of people off guard, especially for persons who are coming from countries where perhaps there's a common law marriage requirement, or you might be domestic partners but not legally married, lawfully married according to that country's laws. Under U.S. immigration law, unfortunately, there is a pretty strict requirement that the person needs to be lawfully married to their spouse in order for the spouse to qualify for benefits. For children, there's a lot of specific kinds of situations, but the general rule of thumb is that they're your biological children under 21. They can still qualify to apply as dependents. And then for other family members, such as parents, those unfortunately are not considered as direct dependents. You may be able to petition for them in other ways once you get your green card, but it's done in a different way, in a different category that may take a longer amount of time. The question is, for persons who are applying for the EB2 NIW, will their family members be able to also get green cards as well? And the answer is it depends on the familial relationship. For spouses, if you are lawfully married to your spouse, that spouse is able to apply for a dependent green card under your EB2 NIW card. Bear in mind that you and your spouse have to be lawfully married. So in some countries, there are common law marriages, or you may be in a domestic partnership, and unfortunately those don't meet the requirement that U.S. immigration law has for a lawful marriage. So you do need to be fully lawfully married. You can also have your children who are under the age of 21 apply for dependent green cards directly as well through your process. For other family members such as parents, there is a different mechanism that once you have your green card, or later down the road once you become a U.S. citizen, you could potentially petition for those family members, but it's done in a different process, in a different way that will likely take a longer time. So the question is, can someone who looking to get a green card apply for the EB1A category even if they're not in the United States? And the answer is yes, they can. The overall green card process takes place over two main stages. The first stage is filing an immigrant petition with U.S. Immigration, and that petition is where you're actually asking U.S. Immigration to classify you as someone of extraordinary ability under the EB1A. And then the next step is to apply for the green card actually itself. So there's one of two ways you can normally do that. If you're already in the United States, you can try to apply through what's called adjustment of status, and that is considered a direct application for a green card while you are in the U.S. But if you are outside the U.S., you can apply instead at a U.S. consulate for an immigrant visa. So you ask a local U.S. consulate where you are to grant you an immigrant visa stamp in your passport. And if they approve that, you can travel to the U.S., show that immigrant visa stamp to U.S. Customs, and they should allow you to enter the United States as a U.S. permanent resident at that point. So the question is, can an applicant apply for a green card through the EB2 NIW category even if they're not in the United States? And the answer is yes, you can. The overall green card process takes place over two main stages. The first stage is a petition filed with U.S. Immigration to classify you under the EB2 NIW category, and that's where you're asking U.S. Immigration to approve you, to consider you as someone of interest to the nation of the United States. And then the next step is to apply for the green card itself. You can do that through one of two ways. You can either apply through adjustment of status directly if you are already in the United States lawfully, or if you're outside the U.S., you can apply instead for an immigrant visa at a U.S. consulate. So you would schedule an appointment with a U.S. consulate near to you outside the United States, If the consulate approves your immigrant visa, you would then travel to the U.S. using that visa, show the visa stamp to U.S. immigration authorities, and they should admit you in as a U.S. permanent resident. The question is, do professors at universities or colleges outside the U.S., do they have an advantage or stand a good chance to qualify for the EB1A? And the answer is it depends. Having a professorship by itself doesn't necessarily qualify you. It doesn't necessarily automatically show to U.S. immigration that you qualify under the EB1A extraordinary ability standard. But if you are a professor who has achieved a high level, if you can show that you do have objective evidence that you've reached an extraordinary ability level, and is related to your professorship, then you can certainly present that, and it'll certainly help you apply for the EB1A. The question here is, for persons who are already in the U.S., if they're working as an adjunct professor or a professor but not on a tenure track with a U.S. college or university here, are they still able to apply for the EB1A? Will the fact that they're not on a tenured track or that they're only an adjunct professor count against them in the process? And the answer is not necessarily. If that person is able to show that they have objective evidence that they have reached an extraordinary ability standard, U.S. immigration isn't going to count the fact that they don't have full tenure or that they're not a full professor at a college or university. They're not going to use that or count that against the person necessarily. The question is, does it help an applicant for the EB1A to have gotten a degree from an elite college or university, either in the United States or elsewhere in the world? And the answer is it can. I think one of the things that U.S. immigration does look at is the person's, if they have reached a high level of achievement, that will sometimes accord with being admitted or being able to get into an institution that does have a good reputation in the field. And that is an argument that I have put forth for some clients before who have applied for the EB1. It doesn't necessarily mean, though, that if you didn't go to one of those institutions that you're locked out from the EB1A. You can always, of course, show other forms of evidence showing that you meet the criteria. You don't necessarily have to have gone to or be admitted to an elite institution in order to qualify for the EB1A. So the question is there a quota for EB1A green cards per year? And the answer is yes, there is. So U.S. immigration law provides for a specific number of immigrant visas to be granted per fiscal year. And then the U.S. immigration subdivides those available numbers down into the different categories. So EB3, EB2, and EB1. That's not all of them, of course, but that's how they do subdivide tranches of those numbers into those categories. And traditionally, the categories that are easier to qualify for, the EB2 and EB3, have also seen higher demand, of course, and that translates into those numbers being used faster and the availability of those numbers to be much lower. For the EB1, it is a quote-unquote higher standard, and up to now, to date, those numbers have not been used. Usually results in immigrant visa number availability being good for persons from all around the world, including the countries that U.S. immigration considers as quote-unquote oversubscribed. So those are persons coming from China, India, Philippines, and Mexico. So the question is, are there any kind of PhD subjects that will likely qualify somebody for the EB1A qualification? And I'd say there's not really one field or the other that'll advantage you. I will say that there are certain fields that will be harder to qualify for the EB1A. And it's mainly due to if you are in a field that already has a high population of persons in it. You're going to have to compete against that population and show that you are at the very top of that population, that you have extraordinary ability and you have reached the top of that field of endeavor. So here's an example. If you have a person who is saying that they are of extraordinary ability in computer science, that means that you're competing against persons like Bill Gates, Marissa Mayer, Steve Jobs, these very, very famous persons who are of extremely high profile. And also, computer science in itself is a very, very wide open field. Versus, let's say you have someone who's working in machine learning. Machine learning, of course, is also becoming very popular, very useful in today's world, but it's a much more focused population. There are arguably fewer people who have reached the top of that field so far to date. So you have an easier argument there. If that's your field, you have a much, I wouldn't say a much easier time, but you're going to have a relatively easier time showing that you are someone of extraordinary ability, that you have reached the top of that particular field. The question is, even though EB1A stands for, it is one of the quote-unquote employment-based categories, why don't you necessarily need a job offer or an employer petitioner sponsoring you for the EB1A? And the answer is because it's the way that the immigration law was written. The EB1A does not necessarily require a job offer. Specifically, it doesn't require a U.S. employer or any kind of petitioner to test the U.S. job market. The U.S. Congress, when writing this law, they were looking solely at wanting to bring people who have extraordinary ability to the United States. That's what they were prioritizing. And because the law was written in that way, it means that no job offer or no employer petitioner is actually required. The focus is on showing that you're going to have extraordinary ability and that you're going to be using that extraordinary ability in the United States. So the question is, even though it's under a quote-unquote employment-based category, why do applicants going through the EB2 NIW, National Interest Waiver category, why don't they need an actual job offer or an employer sponsor? And the answer is, it's because that's the way that the immigration law was written. It's fit under the general rubric or the general framework of employment-based green card categories, but the national interest waiver specifically is prioritizing people who will be in the national interest to the United States. The United States Congress decided when writing this law that they didn't want to have an employer try to test the job market, that the priority was that because this person's work is going to be benefiting the United States in some tangible way, that an actual job offer or testing the job market to show that this person wouldn't hurt Americans, the test was not necessary, because the tangible benefit of showing someone's going to benefit the United States as a whole was more important. So the bottom line is that you don't necessarily need an employer petitioner or a job offer for the EB2 NIW category. So the question is, to qualify, in qualifying for the EB1A category, can the applicant have any field be their field of extraordinary ability? And there is some limit to that. So I always tell folks that they don't necessarily need to be in a science, technology, engineering, or math, or a STEM field necessarily, but they do want to also try to observe what the law says. And what the law says is that the applicant has to demonstrate extraordinary ability in the sciences, arts, education, business, or athletics. And you do need to make sure that your field, your particular field, fits in one of those. There is still a law governing it, so you can't just simply say that any field is going to go, any field is going to qualify. You'll want to tie it to one of those broader categories, and tie it plausibly.
Can you add a bit about how it can be more specific? Because I think people might think, oh, the category is business, but actually it isn't. It's usually like much more narrow than that, right?
Yep. Sure. So the question here is, in qualifying for the EB1A, what kind of field do you need to show you have extraordinary ability in, and how focused can you be for that field? And the answer is that you can drill things down a bit. You don't necessarily, as an example, if you work in computer science, you don't necessarily need to just limit your field of expertise as computer science. If you work in a specific kind of computer science, and that's your specialty, you'll want to call that out. For example, one of the the cutting edge fields right now is natural language processing, NLP. It's a subset of machine learning, so it's actually even kind of a subdivision of that. But it's an emerging field, and there's not necessarily, relatively speaking, there's a lower population of people total in that field, even though it is popular and growing. But if you are an expert, if your expertise in that particular field, you'll want to tailor your case, focus your case on that. There is a warning there that I always tell folks, in that you don't want to tailor yourself too narrowly. The classic example is that you define a field where you're the only expert. U.S. immigration is going to say that doesn't pass the smell test for them. They're going to say that you've narrowed this you've tailored this too narrowly. That this isn't an actual viable field. So that's the only caution I would give there. But you do want to focus, and you can specialize your field, definitely related on what your expertise is about. So one of the potential criteria you can show to show that you qualify for the EB1A extraordinary ability category is that you have high remuneration, that you earn a high salary compared to others in your field. And especially recently, U.S. immigration has looked at salaries in the United States compared to those in other countries. So unfortunately, that does mean sometimes that, especially for persons coming from countries where the standard of living is not going to be on the level of the United States, or where salaries are not necessarily going to be on that same level, that may hurt you, that may count against you. One of the other things that I do see a lot in EB1A cases from U.S. immigration is that this is one of the hardest criteria to meet. And what I mean by that is that you typically need to show that your salary is at such high level that it clearly is well above salaries that are normally earned by others in your field, and by others who are similarly going to be working in the similar kinds of roles or positions that you'd be working in. So you do have to clear a high bar in itself already, as well, for the high remuneration criteria. The question is, are there specific nationalities that are not going to be qualified or not going to be eligible for the EB1 or EB2 NIW green card categories? And the answer is no. Persons from pretty much any country can actually apply, can petition for the EB1A or the EB2 NIW categories. But where you're going to run into a potential barrier is there's the second step of the overall green card process, where you're actually applying for the green card or for the U.S. permanent residence itself. So as a refresher, this whole process takes place over two main stages. The first stage is the petition to qualify you as either under EB1A or EB2 NIW, asking U.S. Immigration to consider you as under one of those categories. And if that initial petition is approved, then you'd be doing the next step, which is applying either directly for a green card for adjustment of status if you're in the United States, or for an immigrant visa if you're outside the United States and you want to try to apply through a U.S. consulate. It's that second step where you may run into a barrier if you are from certain countries, specifically those considered by the U.S. as state sponsors of terrorism. So that's going to include countries like Iran, Syria, North Korea. Those are the ones that are coming to mind immediately. But that's where you may run into an issue, as you are going to likely be blocked from proceeding if you're going to be coming from one of those countries. If you are from one of those countries and you're considering this path, I very strongly suggest you speak with an immigration attorney and go through your situation so you can understand what the risk factors are going to be there. The question is, for one of the EB1 criteria, applicants can show that they've had press or media mentions about them and their work, and a lot of times you'll have press or media mentions regarding a company and their product or their work and what they've done, but those articles don't necessarily mention the individual person who's actually trying to apply for the EB1 category or the EB2 NIW category. Can applicants in those situations use those articles still to try to qualify? And the answer is potentially yes. What you'll want to do is to link the article, the information in an article about the employer or the organization's work directly to the work that you were doing. So even if the article may not necessarily directly mention you by name, if it is evident through other ways that the work, let's say the article is talking about a particular product that the company developed and sold and made, lots of revenue and had huge success on, if it's evident through surrounding evidence, if you can show that the related evidence clearly connects you and that you're responsible for that particular product, you may be able to still use that article. And you can make the argument that, your particular work had outsized reach and shows that you are a person of extraordinary ability. But again, it's going to be on you to supply that additional objective evidence to show the context to U.S. immigration. The question here is if an applicant's just been quoted or cited in a news article just about any topic, does that count towards this criteria? And the answer is not all the time. If you're being quoted or interviewed by a newspaper or TV, like a news agency or similar, the interview and the subject matter has to be related to your field of extraordinary ability. You can't say that, for example, you're someone who's of extraordinary ability in fashion design, but then present an article just asking you about your opinion about a TV show. Unless that TV show, of course, is in fashion as well or something similar. But the idea is that it has to make sense. It has to be related to your field of extraordinary ability. The reason the media outlet is interviewing you is because they are considering you as someone who's being a leader at being the top of your field. A question that comes up a lot is what kinds of media or press mentions count? Is it only just traditional newspapers or traditional print media, or can it be other things like online media? And the answer is it absolutely can be other things like online media, especially today with a lot of newspapers moving to online only subscription or publication models. Sometimes the only press that you're going to have for you is going to be online only. You'll want to show that the media mentions that you have are from outlets or media outlets that are considered major. In other words, that they have a wide audience, that they reach a wide number of people. Oftentimes, I will go to websites like SimilarWeb, or there's another website called Mondo Times that shows circulation numbers for both traditional print, TV outlets, radio outlets, and online media as well. They'll show how many people either visit those websites or how many page impressions those sites get, and you can present that alongside the articles themselves to show that these articles are reaching a wide audience. And because of that, your work is having a huge impact on the field or just in general.
To have your question considered for an upcoming video, you must follow or subscribe, then comment with your question. Visit permanentresident.us to watch more videos on self-sponsoring your green card, or go to our permanentresident.us account on this app to watch the next video.